Welcome back to another NCBA Coffee Break. I'm your host, Nathan Willner, and today we're diving into one of the most consequential regulatory developments the debt collection industry has seen at the municipal level in years. The newly finalized New York City Shield Rule, which becomes effective on September 1st, 2026. And to help break it down, I'm joined by someone who knows the New York City regulatory environment inside and out. Scott Morris is a veteran New York City attorney with more than 2 decades of experience representing creditors, collection agencies, and financial institutions. Scott has defended creditors before the New York City Department of Consumer and Worker Protection and has been directly involved in numerous rulemaking comment processes at both the state and city level. Simply put, there are few people better positioned to walk us through what this new framework means for industry. So, Scott, great to have you with us today.
You're too kind, Nathan, and it's always a pleasure to be with you. And now I just wish I liked coffee, considering this is a talk. So maybe we change it to apple juice break next time.
Well, I'm glad that you don't need anything stronger than apple juice to get you through the day, Scott. But we will, whatever you need to drink, we'll get it for you. So let's jump right in because this shield rule is big. A lot of people are talking about it, and it's going to touch every corner of the New York City debt collection industry and definitely have national implications. So let's start with what I think is the most surprising shift for many in the industry. The shield rule doesn't just regulate third-party collectors anymore, does it?
It does not.
It brings in original creditors into the regulatory framework, and once they engage in what the city calls debt collection procedures, meaning the moment they stop periodic statements, accelerated balance, or even threaten legal action, they're now regulated as collectors under New York City rules. So, from your perspective, what does this mean for financial institutions, hospitals, utilities, and anyone with consumer accounts in New York City?
So it's a great point, and I guess just to bring us back to where this was before all of a sudden this came upon our desk a few weeks ago, Nathan, is in 2024, the rules were supposed to be rolled out. And inevitably, as part of that rollout, they there was a discussion on just rules clarification where they said, oh, the original creditors were involved in this and they are included. And essentially what they did was they explicitly amended the rule to add the original creditors in. And what the 2025 does is I think it raises some areas where the original creditors may not be as frustrated with this as they were in 2024. A few examples of that is we're going to talk, I believe, in a few about the communication requirements, which is the 3 communication limit per week. But the big thing now is that original creditors are exempt from it, so long as it's within the ordinary course of the creditor's business unrelated to debt collection practices. So I think a lot of the things that the banks and the financial institutions were really frustrated about is that the city of New York was telling them not only how to do debt collection, but how to do their day job. So I think some of that stuff is changing. The other thing that is a big deal that, again, I think we'll talk about later on in this conversation is around the debt validation process. And for debt buyers, law firms, agencies, if we are unable to validate within 60 days, there's a notice of unverified debt, and you have no choice but to close the file forever. The original creditors are now exempt from that as well. So if they are able to verify the debt, even if it's after 60 days, they can reopen the account for collections and they could start. And the last part, which makes things a little softer, is credit reporting. There is a credit reporting requirement that says that there's a 14-day provision that you have to wait to give the consumer notice that you are going to start credit reporting. Original creditors are exempt for that under their federal obligations under the FCRA. So while this is still taxing for original creditors do not have to be licensed by the DCWP. And with the few carve outs that happened in this 2025 iteration, it is still too early to be said, but I don't know if the original creditors are going to push back with the DCWP like they did in 2024, which caused all of this to be stayed for an indefinite period, which now we know is until September 1 of 2025.
Yeah, so and I want to talk about the communication limits and operational impact in 1 second, but I want our listeners to realize they might get confused. Like, why are we talking about New York City? Doesn't the New York State have some rules? Doesn't the CFPB have rules? So I just think that what most people probably are going to be most shocked about that don't work in New York area is what that why is New York City telling us what to do?
So, I mean, it's a great point, Nathan. And, being a New York City resident for many years and born and raised in New York, you often think New York City is New York State. And when you have 8.5 million people that make up a state that I think has 20 something million or maybe close to 30 million people, it's about one third of your population and probably 10% of the landmass of the state. And most of the state budget goes towards New York City. So it really does have a huge influence on the politics of the city of New York. I mean, just think about it from a landmass. New York State probably is mostly a Republican or moderate liberal state. But when you get down into the five boroughs, it really does become much more democratic and more woke. So it really does have significant influence on everything that happens in New York State politics.
So, I constantly say how the creditors' rights attorneys are the most regulated attorneys in the country, but really it's the New York City creditors' rights attorneys are the most regulated
In
attorneys
the
in the
city.
country. So aren't you lucky, Scott?
Yes, that's why I always say, Nathan, if I could make it here, I could make it anywhere, just like Frank Sinatra, right?
Absolutely. So with that, let's move on to communications. So New York City has now locked in one of the strictest contact caps in the country, no more than three total communication attempts per week per account. And the cap applies across all channels. So phone, email, text, even social media attempts are counted together. So we're already hearing from agencies and creditors that this is going to reshape the entire contact strategy architecture. So how do you see this affecting the day-to-day creditor outreach? And what operational pitfalls or compliance traps do you think creditors and debt collectors need to prepare for right now?
It's a great conversation, and I think the funny part about this rule is the DCWP. I think takes the stance that they relented on this a little bit because if you look at the current law that we're under now, you're only allowed to make two calls per week under the current DCWP rules, which has been going on since I believe 2004, 2005, something like that. So their perspective is oh well, we're giving you more ability to communicate, but what they don't realize is email, SMS, there was never any requirements around along with making sending out letters. So this is really going to change the landscape because it includes all communications. The only communication, ironically, Nathan, that doesn't get included in this is US mail. You could still send as many letters as you wish to, but we all know how expensive the US mail is getting. So it is not as viable as an option as it used to be. The other thing is that they did clarify the rule a little bit. It used to be that, with the 2024 iteration, that you could only speak to a consumer three times per week, not per account, but per consumer. So if you had four files against John Doe, you could only speak to all four of those accounts up to three times combined. That was really a troublesome rule because it's really hard to have the infrastructure to know between each account how many times did you speak to, which ones did the consumer want to speak to specifically. So they did clarify the rule that it is now per account. So if you do have a consumer with multiple accounts, you could speak to the consumer or attempt to speak to the consumer up to three times per week per account. But this is going to be really difficult for certainly agencies, law firms. There are carve outs. Again, if the consumer reaches out to you via email, you are allowed to reach out to them, to respond to them, and it doesn't go against the call caps. And there are other additional exemptions or exceptions, I should say, that everyone should read. But this will definitely have some type of effect on the amount of times you could try to reach out to consumers.
Yeah, I'm definitely glad that it's per campus, especially when we're talking about litigation. You can have multiple cases going at the same time. How would how could you only contact the consumer one case, not the other. I could see it being a big problem. But the city signaling at this point strong enforcement of these rules. Do you expect more audits or investigations around the communication frequency, or what do you think's going? How do you think they're going to police this?
It's a great question, and it's the biggest unknown, Nathan. I mean, the DCWP has not been one that has done many enforcement actions over the years. However, as we all know, with the CFPB not having the power that it's had at the federal level, we've definitely seen many CFPB employees and enforcement agents moving to the New York State Department of Financial Services and also to the DCWP. So we do expect to see more enforcement, but only time will tell.
Yeah. And another major piece, and frankly, one that's most labor intensive, is the updated dispute and verification process. Consumers now can dispute at any time, and collectors have 60 days to verify it. And verification now means original account level documentation, not just a summary, not a judgment, not a data file. So during that entire period, collection activity has to stop. So, what do you view as the biggest challenge for collectors and creditors in meeting these verification standards? And how significant is the operational impact of a mandatory pause of debt collection?
So this is probably the biggest part as an attorney that I think affects the legal world, and it's probably the most concerning for attorneys and debt buyers. I think the biggest one is the definition of a validation period is gone, right? In the city of New York, a consumer could request validation or verification of the debt at any time. I mean, if it's in the middle of a litigation and the consumer filed an answer, but they also request validation, you got to supply it to them, which doesn't make any sense. There's a legal matter going on. It's redundant, but those are the places where you have to do it. You cannot send electronically in the city of New York your model validation notice. I know a lot of agencies and debt buyers are starting to use electronic form sending of the MVNs as a means of their initial validation notices. In the city of New York, that's not going to work. You must send it via snail mail, even though we know the U.S. Postal Service is not as reliable as it used to be. But you got to do it, and it costs money, and it certainly is going to affect the way some agencies have to revert back to being a little bit more old school. I think the other part, Nathan, that is still going to be very difficult is, the MVN is really action packed on the front side with lots of information. And I think most creditors appreciate what the CFPB did with Reg F and the MVN notice. But now the DCWP is asking to add even more disclosures to that document. And it certainly won't fit on the front side, which in 2024, they kept using the term clear and conspicuous, and they kept inferring that it had to be on the front side. Now they've clarified in 2025 that as long as you put on the front side of the document important additional consumer rights under New York City law as a disclosure, could put the New York City disclosure on the backside. And the New York City disclosure talks about essentially three things: that there is no limit for New York City consumers to dispute the debt. You could do it at any time. You must get a response to disputed debt within 60 days. Otherwise, you do need to, you should be expecting to receive a notice of unverified debt. And then we do need to inform the debt collector, even if the debt has nothing to do with medical. There's now a new medical debt disclosure that says if you have a low or limited income, you may be eligible to apply for help under a hospital's financial assistance policy. Medical debt cannot be reported on your credit report, yada, yada. There's a little bit more to it. But inevitably, that doesn't make any sense to me. I understand if you're collecting on medical debt that you need to have a disclosure, but now we have to put it on everything. The bigger ones,
So,
Nate, oh, go for it.
yeah, no, go ahead. No, listen, I'm listening. Go ahead.
Yep. I think the next pieces of it, of what I want to talk about, are where it really becomes concerning as a debt collector. And the first part is itemization. There's validation itemization, and then there's verification extended itemization. For validation itemization, if you are putting anything that is post charge off or post the date that you're putting in your validation, and there's only 3 dates that you could use for the city of New York versus the 5 itemization dates you could use for federal. If you have any post itemization date, you actually need to advise why you are entitled to such information. So if you have a judgment and you're accruing interest, you got to say, pursuant to the CPLR at 2% per annum, that's why I'm entitled to that money. If you have fees or costs, all of those things have a little note, which I don't even know how we're going to put that in the MVN. It's going to be interesting to see what people do to do that. On the verification side, if a consumer disputes a specific type of post itemization amount, i.e., interest, cost, fees, you have to be able to prove why you are entitled to that money and put it into your response for validation. So that's going to be a lot of extra work, a lot of extra time and effort. And the repercussions of it potentially could be that, there could be, mistakes made and consumer attorneys possibly looking to file suits. Now, this does not have a private right of action when it comes to this law, so that's something to be important about. But I'm sure the consumer bar may see mistakes being made due to the specificity of this, and therefore may find that their consumers have, had, abusive collection practices or mistakes made that may impact them and may raise FDCPA claims. I think the last part of this, Nathan, that I really wanted to talk about is judgment validation. This is where I think the city of New York really went off base, and I think they're being unfair. The new rule says that if you are validating a debt on a judgment, which we all know as an attorney at law in the United States has full faith and credit, the city of New York does not see that way. If it's a default judgment, in order to validate the debt, you need to have the underlying prima facie validation, like you said, which is, having proof of a contract, having proof of credit card statements, charge-off statements, a chain of title, and all the other stuff. If any of that's missing, and you can't do that, and I should note, it's only on debt that it was purchased after 9/1 of 2026 for debt buyers. For original creditor, it's for anything they validate after 9/1 2026. You essentially would have to treat it as an unverified debt, and you'd have to close your account. So think about that, Nathan. You literally would have the city of New York telling you that a judgment rendered by the court system of the state of New York is no good here, and you have to close your file. I think that's a big, big mistake. And I think that is not only a federal constitutional violation, but I think it's also a state violation, as the CPLR is crystal clear to say that a default judgment and a judgment on the merit have the same exact value and merit in the eyes of the courts of the state of New York.
And then you have problems with judgments that were obtained in another state and then get enrolled possibly in New York. What do you do with those? How do you have the document? Is it go from the date of enrollment, the date, the original judgment? Maybe, who knows, right? I mean, again, what we really wanted was clarity in these rules. And that's something that as an industry we look for. And it just seems like they're not so clear.
No, and remember, there's definitely some biases to this. I mean, if you look at the notes around why the DCWP is limiting even languages, which we talked about before, they essentially are saying that because of 600 complaints, I think over a 2 or 3 year period, it was significant enough amongst 8 million consumers in the city of New York that they had to do that. I mean, if I run my math, that's like 0.0001% of all consumers. And think about all the millions and billions of communications that happen between creditors and consumers. So I actually look at it as a really impressive stat, because there's always some bad actors. And I'm sure out of those 600, not all of them are really bad actors. So it's really amazing how they've tried to implement these laws when, as you said at the very beginning, we are so over-regulated as an industry, and all we're trying to do is the best in representing our clients to the full, value of the law that we could do, but also be cognizant and respectful to consumers as we do it.
Yeah, and I also see lots of problems down the road, and you could have situations where there are partial payments made or other types of involuntary payment type of garnishments. Where what happens if the consumer stops it in the middle or starts suddenly, even if they made a voluntary arrangement, now suddenly you're saying, well, I don't really know. I wanted to see, stop the whole process, unwind it. I mean, I could see this creating really crazy operational problems for the whole industry. And then again, you're asking for a municipality to have a different set of rules operationally from the state, from nationally, especially when you're dealing with large creditors. It's good. I think that's why they say if you can make it there, you can make it anywhere because it's not so easy to make it there, Scott. So
No, and your point on the garnishments is a huge one, and it's one that concerns me because think about it. I don't send out the wage garnishment to the consumer or the bank levy. The sheriff or the marshal of the state of New York or city of New York do that. So if I get a request for validation, I can't do what I do today, which is within 24 hours, I'm sending out the judgment, verifying the debt to the consumer. So I don't even have to let the sheriff or marshal know to stay the enforcement period. Now, because of the significance, I have to now tell a sheriff or marshal to stay in enforcement action. They now have to tell the employer or the bank to do that. I could tell you, there's times where banks take 3-4 weeks for them to respond to any communication. So consumers may feel and consumer attorneys may feel like we're violating the law when it's totally out of our control. And we've made the effort to try to stay the action. So it is going to create a lot of uh, unforeseen issues with, creditors, attorneys, agencies, and debt buyers and original creditors, where it looks like we're violating the law when it's out of our control. So this is going to be really burdensome on our industry.
Well, now you know why you need a stiff cup of coffee to start your day. I'm sorry that coffee is not your jam, but this has been incredibly informative, and the Shield Rule is going to reshape compliance obligations across the board, particularly original creditors, anyone touching medical debt. So, as always, your insight helped cut through a lot of the complexity. So, Scott, thank you so much for joining us. What's your final word of the day before we have to say goodbye to our listeners?
I think, just stay tuned. I think there is going to be a lot of conversations around whether the industry is going to fight this, whether there will be any clarification by the DCWP on any of their stances as they feel the pressure from the creditor's side. And, definitely make sure you listen and, stay tuned as to all of the different implications. So that way you could, work to get your firm, agency, or financial business up to par and compliant with this rule. But it is going to take time. September is not that far away, and there's a lot to implement. So best of luck to everyone.
Yes, and thank you so much. This was a great conversation, and hopefully we'll have you back to talk about how this thing is working once it's up and running in New York. And so, to our listeners, stay engaged and most importantly, stay caffeinated. I'm Nathan Willner, and thanks again for listening to NCBA Coffee Break. And thank you to our guest, Scott Morris, for fighting the good fight and keeping us all informed. So thanks, everyone. Have a great day.